Can you hear me now, sir?
Yes, your case, I'm gonna put you back. Your case is not called yet.
All right, good morning, everyone. Court will begin with the August 10th, 2022 docket. And I have Mr. Frank Martinez and Mr. I want to say Rick Gonzalez.
Mr. Gonzalez is trying to join. I brought him in earlier. He didn't have any audio.
Okay.
And I don't know why he's under Hidalgo,
I don't know.
unless he had a name change.
All right, can you hear me, Mr.
No.
Judge.
Yes, I can hear you, Mr. Martinez. Good morning.
Good morning, Judge. Good morning.
I'm trying to get in Mr. Gonzalez.
Okay.
I see him, but I don't think he can hear me. Why can't I hear him either?
Where's Mr. Martinez's client? I need a name.
He's right here.
Okay.
Okay. Okay. And what is his name, Mr. Martinez?
Mr. Luis Cavazos, Judge.
Luis.
It's a fine. This is the final hearing, divorce.
Luis Cavazos. All right. All right, let me see if I can get Mr. Gonzalez. Holiday Cavazos is a petitioner.
That is correct, Judge.
Okay.
Maybe we can take care of the name change. Number one.
Okay. A little bit of pause here, Mr. Martinez. I'm going to move into something else until I can get Gonzalez in. Just
Yes,
put your
sir.
pause, okay?
Yes, sir. I'll go on mute.
Mr. Fonseca's here.
Mr. Fonseca, can you hear me?
I can, Your Honor.
All right, your case. We're here. We're continuing with the August 10th, 2022 docket. Your case is A0057-22-4 in the interest of Isaiah Escamilla.
That's correct, Your Honor.
All right, and we're seeking what? Is an adoption here?
Yes, it's a petition to adopt an adult.
Okay, and you're going to put in some testimony?
Yes, Judge. It'll be very brief.
And your client?
Is Monica Ramos and Carlos Cantu.
There's the Carlos right there. And unless they're together.
I hope all three of them are together.
Okay. I'm going to see a Carlos. And hopefully all of them are together.
Need to unmute and video.
All right, there's Carlos in there, but he's doing, I think they're together. There they are. Okay.
Yes.
And they need to unmute.
Okay.
All right. Can you all hear me?
Yes.
All right. Good morning. Mr. Fonseca, you were going to call a witness, right, sir?
Yes, let me call Isaiah Michael Escamilla.
Isaiah Michael Escamilla. All right. Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down and listen carefully to the questions. Mr. Fonseca?
Mr. Escamilla, you filed this original petition to, I'm sorry, you are the subject of this original petition to adopt an adult. Is that correct?
Yes.
And what is your full name for the record? Sorry, I forgot to ask.
Isaiah Michael Escamilla.
And you're the same person that is the subject of this this petition, correct?
Yes.
Okay. And are you there with your mother?
Yes, and
And who is your mother?
Monica Ramos.
Okay. And she's your biological mother?
Yes.
Okay. And you filed also a consent to the adoption, is that right?
Yes.
Okay. And how old are you today?
18.
18. So are you asking that the court approve this adoption of an adult?
Yes.
And who is going to be adopting you?
Yep. Carlos Cantu.
Okay. And who is Mr. Cantu to you?
My dad.
Your dad, but not biologically, correct?
Yes.
Okay. How long have you known him?
since I was 1.
Okay, so you consider him your dad already, correct?
Mm-hmm.
Okay. Can you say yes or no, please?
Oh, yes.
Okay. Sorry, it's just because when we make the record, it has to actually be verbal. Okay, I'm gonna go ahead and oh, I'm sorry. Mr. Escamilla, are you asking the court also to change your name?
Yes.
What are you asking the court to change your name to? Is it Isaiah Michael Ramos Cantu?
Yes, sir.
Okay. I'm gonna go ahead and pass the witness, Your Honor, or I have no more questions for him. I mean, go ahead and ask the adoptive dad.
All right, and that'll be Mr. Cantu.
Yes.
All right, Mr. Cantu, good morning, sir. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I swear.
All right, you may put your hand down. You may proceed, Mr. Fonseca.
Mr. Cantu, can you please state your full name for the record?
Carlos Cantu III.
Okay, and you're the same Carlos Cantu III that filed this original petition to adopt an adult?
Yes, sir.
Okay, and who are you asking the court to have you adopt? Who are you adopting?
Isaiah Michael Escamilla.
Okay, and who is he to you, sir?
He's my son. He's my stepson. I've raised him since he was about 1.
Okay, and you're asking the court to formalize that adoption so that it's comes with all the legal rights, correct?
Yes, sir.
And you understand that he will have all the natural rights as a biological son to you, meaning that he can inherit through you?
Yes, sir.
Okay. And how long have you known him?
Since he was a baby, since he was just a little over 1 year old.
Okay, and you're asking the court to approve this adoption, correct?
Yes, I am.
Okay. Next witness, Your Honor?
Okay, and that'll be Ms. Monica Ramos.
Correct, Your Honor.
Okay. Good morning, ma'am. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. You may proceed, Mr. Fonseca.
Good morning, Ms. Ramos. Can you please state your full name for the record?
Monica Ramos.
And Ms. Ramos, you are the biological mother of Mr. Escamilla?
Yes.
Okay. And you've heard all the testimony that's already been put on the record. Would you agree to that?
Yes.
All of that is true and correct?
Yes.
And you're asking that the court approve this adoption of an adult?
Yes.
Your Honor, I have no further questions. We're asking that the court grant this adoption of an adult and take judicial notice of all documents within the file.
All right, thank you, sir. Court will take judicial notice of the entire file in A0057-22-4. In the interest of Isaiah Escamilla, court will hereby grant the adoption of an adult for petitioner Carlos Cantu III, and court will furthermore grant all relief requested here for petitioner, including the name change. Court hereby orders that the name be changed from Isaiah Michael Escamilla to Isaiah Michael Ramos Cantu. All right, anything else?
That's it, Judge. Thank you so much. I appreciate it.
All right, congratulations, Mr. Cantu.
Thank you.
You all have a great day, okay? You all celebrate now. Okay, thank you.
Yeah, we will. Thank you, sir.
All right, thank you,
Thank you,
bye-bye.
Judge.
Bye-bye.
Number 2. I think Mr. Gibson is here for Baltimore.
All right, I think we have a friendly suit here. Let me see.
Good morning, Judge.
Good morning, Mr. Gibson. Are you here? Are you here
Quite
for
a
Mr.?
while.
I know. Are you here for Mr. Juan Zamora?
I am, Your Honor.
All right, I just want to make sure. And then I think we have Roger Garcia. There he is.
Good morning, Judge. How are you this morning?
Fine, fine. Good morning, sir.
Wonderful.
And then who else we need?
Mr. Daniel Hernandez is the ad litem.
That's right, Mr. Daniel Hernandez. I heard he was busy with the mediation. I wonder if he could get off for a while here.
You want me to call him, Judge?
Well, what we can do is get started with some questions here, and then when he comes in, he can finish it off. Right?
Yeah, we can call him or text him. This is quick.
Yeah.
Would you
Yeah,
let me
Mr.
text Mr. Hernandez?
Okay. Yeah, he did tell us earlier that he was going to be busy, but I think in a couple of minutes here, he can wrap this one up.
Where's Mr.
I know.
If Frank can call him?
Yeah. Mr. Martinez, I don't know if you can hear it. Mr. Frank Martinez,
Yes, sir.
could you please call your opposing counsel, Mr. Gonzalez, see if you can get him on?
I will, Judge. Let me do that
All
right
right.
now.
All right, thank you all. I think we
Judge
have Mr.
Garza.
Hernandez already.
I apologize.
I just texted, I'm sorry.
I apologize about that. We're ready to proceed. I apologize.
No problem. I heard you were busy with the mediation. Real quickly here, court will take judicial notice of the entire file in CL 22-2503D in the case of Cruz Antonio Lopez and Elisa Lopez's next friends of minor versus Geico County Mutual Insurance. All right, and who's going to get it started, Mr.
Whomever you'd like.
Yeah, Mr. Gibson, you want to get started, or should we let Mr. Garcia?
I have really no questions. I'll let Mr. Garcia proceed.
All right, Mr. Garcia, you've been
Yes,
voluntold. Yes, sir.
Thank you, Your Honor. Thank you.
Yes, sir.
Your Honor.
Okay.
Ms. Lopez, good morning. Can you give us your name for the record, please?
Oh, wait a minute. Ms. Lopez, you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I swear.
All right, you may put your hand down. Mr. Roger Garcia, you may proceed, sir.
Thank you, Judge. Ms. Lopez,
Yes, sir.
can you explain, please, ma'am?
Elisa Lopez?
Ms. Lopez, I understand that you are the mother and next friend of minor Ashley Lopez. Is that correct?
Yes, sir.
Ashley was born on September 1st, 2009, making her 12 years old.
Correct.
And I understand that your daughter was a passenger in a vehicle that was in a accident on May 14th, 2021 in McAllen, Hidalgo County, Texas. Is that correct?
Yes, sir.
Ashley was injured and received medical treatment for those injuries. Is that correct?
Correct, sir.
And fortunately, she was able to fully recover from those injuries. Would you agree?
Yes, sir.
Now, I understand that there is a proposed settlement of $14,746 that we're presenting to Judge Garza to consider. Of those funds, my understanding is that an amount of $9,665 will be dispersed, made payable to the law office of Juan Zamora in order to pay attorney fees for medical expenses. Is that correct?
Yes, sir.
There is another check that will be dispersed to TMHP Medicaid in the amount of $179.73, correct? Is that correct, ma'am?
She
Can you-
froze.
I think Ms. Lopez is freezing here.
Miss?
Hello?
Yes.
Okay.
Yes, it's correct.
Okay, great.
Okay.
And a balance of $4,501.27 will be deposited into the court's registry in an interest-bearing account for the benefit and use of your daughter. Are you aware of that?
Yes, sir.
That amount will, those funds will be kept in the court's registry until your daughter turns 18 years of age. Are you aware of it?
Yes, sir.
All right. And it's my understanding that you know that you have a right to a jury trial, but you choose to waive that right, even though a jury could award more or the same or less. It's your preference to move forward and ask the Honorable Judge Garza to approve the settlement. Is that correct?
Correct, sir.
And I understand that you're going to be presented with a document that's titled Settlement Agreement and Release. Do you understand that once you execute that document, that will resolve this case, and you nor your daughter will be able to file an additional claim regarding her injuries? Are you aware of that?
Yes, sir.
And that you nor your daughter will be able to request any additional funds from Geico County Mutual Insurance Company. Are you aware of that?
Yes, sir.
Do you believe this is a just and reasonable settlement?
Yes, sir.
Is it in the best interest of Ashley, your daughter, for this settlement to be approved?
Yes, sir.
Are you now requesting that Judge Garza approve the settlement as presented before the court?
Yes, sir.
Judge, that's all I have for this, and we'll now pass. Thank you. Thank you, Ms. Lopez.
Thank you.
All right. Thank you, sir. Mr. Hernandez?
Yes, sir. Thank you. Good morning, Ms. Lopez. How are you?
Good. How are you doing, sir?
Good. Good to see you again.
Yes.
We visited with Ashley about this process today, didn't we?
Yes.
And she told me she's doing better. Would you agree with that?
Yes, sir.
And can you hear me, ma'am?
Yes. Can you hear me?
Yes. Okay. And we talked about whether the medical treatment she received helped her, and I believe she said yes. Is that correct?
Correct. Yes, sir.
Okay, we went over the numbers and you agreed with the numbers that were going to be paid to the lawyer, to the medical providers, and to Ashley in the registry of the court, correct?
Yes, sir.
And I also explained to you that Mr. Zamora was very kind in reducing his legal fee so that Ashley could get some more money, correct?
Correct. Yes, sir.
Okay. And we also talked to Ashley about her wanting to pursue and become a doctor when she gets out and goes to college, and hopefully she could take care of people like me, correct?
Yes, sir.
All right. So I appreciate the opportunity for us to visit, and I explained to you that this will dispose of the case in its entirety, and you were in agreement with that, correct?
Correct, sir.
All right. And no one's forced you to sign any documents or settle this case, correct?
Oh, no, no, sir. No
Right.
one's forcing me.
Right. And so I asked you if you thought it was in the best interest of your child, and you agreed, correct?
Yes, yes, sir.
Okay. Have I been kind, courteous to you, and spend the time needed to answer all your questions regarding this settlement?
Yes, sir.
Okay. At this time, Judge, I would recommend the approval of this settlement, and I believe that it's in the best interest of Ashley Lopez.
All right, thank you, sir. Any questions, Mr. Gibson?
No, Your Honor, I don't have any questions.
All right, pretty much both attorneys covered everything.
Yeah, I
Court-
mean,
Court will hereby take judicial notice of the entire file. Court will hereby approve the minor's settlement, and court will hereby await a judgment for signature. And each already agree on the fees also for the item?
Yes, Your Honor. Roger,
Very well.
I have agreed. Thank you.
Very well,
Thank
just
you, Judge.
submitted in the judgment.
Everything has been, the final judgment has been circulated. As soon as Mr. Zamora or Mr. Gibson and Mr. Hernandez execute and return it, we'll have it filed hopefully by this afternoon.
All right, thank you all very much. Y'all may be excused. Have a great day, okay?
Thank
Thank
you,
you,
Judge.
Judge. Good to see you.
Thank you, bye-bye.
Bye, Lisa.
Bye. Thank you.
Mr. Martinez, Mr. Martinez, did you find Mr. Gonzalez?
Judge, they said that he's in the probate court.
Okay, all right, in probate court, okay. Then let me see if I can find somebody else in. You gonna bring it? Number four? Okay. All right, number four here. Court will resume with the August 10th, 2022 docket. And let me see if I can get Mr. Hernandez. There he is. Miss Singletary, there she is. And now the parties, Veronica Gonzalez, there. Gonzalez or Hernandez, there she is. And then Mr. Benjamin Hinojosa, there he is. I think we have everybody, right?
Yes, sir. I believe so. Good morning, Your Honor. Agustin Hernandez for Veronica Gonzalez.
All right, good morning. All right, what do we have here? We're here on a motion to enter final judgment.
Yes,
Yes,
Your
good
Honor.
morning, Judge. Nereda Lopez Singletary here on behalf of respondent, Your Honor. I submitted my proposal decree, Your Honor, on this original petition in suit affecting parent-child relationship. We were before this court, Judge, on May the 17th. This is a case that was mediated. Mr. J.R. Garza. The MSA was introduced into evidence on that final hearing, Your Honor. We also put testimony from the parties. The only issue that was pending was the child support and medical support, Your Honor. Medical support was at that point provided by the government. Mother was not in agreement, so father needed information on cost to enroll him under his employer. At that time, Your Honor, that we put everything into evidence, Your Honor, we finalized it. The court said if the parties did not agree to the dates, to the amounts for the parties to submit proposed orders to be e-filed for the judge's signature, Judge. And that's what I did, submitted my proposal with an exhibit attached on calculating child support and medical support, Judge. The issue that we have is that Mr. Hernandez wants us to include retro child support. And there's an issue with that, Judge. One, it was not pled for on his original petition that he filed with the court. He never asked for the relief asking for retro child support, Your Honor. Second of all, on May the 17th hearing, when we proved it up, Your Honor, he did not bring up that issue, Judge, on the retro child support. And the third issue, Your Honor, is that Mr. Hinojosa, when he separated from the mother of the child, he did provide to her cash amounts for groceries, Your Honor. He also, when they separated, they were living in an apartment on the rental lease. She just moved out. So he had to pay those months that she moved out, Your Honor, and she has also kept furniture, even though this is not a divorce, Your Honor, we want for the court to consider that Mr. Hinojosa did provide her with money for groceries, for money with rents, Your Honor, for property, and most important, Your Honor, it's relief that was not pled for, and therefore Mr. Hernandez cannot come to this court and request retro when he didn't plead for it.
Mr. Hernandez?
Yes, Your Honor, if I could please share the MSA, the Exhibit A to the MSA that was filed multiple times into this court. Oh, you
Go ahead.
disabled it. Okay, Your Honor. Well, do you have access to? Oh, can I share it now?
Sure.
Okay. Yes. Thank you, sir. Okay. It says right here on numbers. It says on number 6, Your Honor, after
Number
the
6.
amount of monthly child support is determined by the parties will discuss and agree as to an amount of retroactive child support that is due, if any.
If any. Mhm.
So the MSA says that we have to discuss and agree to an amount of child support, if any. So I believe that takes care of any argument about something not being pled, if that was agreed to in writing and signed by all the parties in an irrevocable MSA, Your Honor. Number 2, Ms. Nereda, Benjamin Hinojosa's lawyer, brings up that there's this issue of money given for rent or for rent or furniture. Now that wasn't pled in any or discussed at all in the past. And if he wants to bring up that claim, he's still within his statute of limitations to bring up that claim. But that wasn't mentioned at all in any of the proceedings that we've had or any of the documents that were filed with this court, Your Honor. Now, when we had the hearing back in May 17th, we didn't discuss the amount of child support arrears because we didn't have the amount of child support agreed to. And we have agreed to it. The judge, because you said in the May 17th hearing, Your Honor, that it was going to be the amount of his, calculated off of the amount of his income, minus the stipend, since he swore that he wasn't going to be making extra stipends this year as opposed to last year. So, Your Honor, I have more evidence in the form of emails that show that Benjamin Hinojosa's attorney wouldn't discuss the amount of retro as required by the MSA. And then I also have an affidavit that I'm willing to introduce that states that Benjamin Hinojosa separated from Ms. Gonzalez on February the 14th, 2022. And I also have my client here for testimony so that she could go ahead and state that she had the child the vast majority of the time between February 14th through May the 1st, 2022. And the proposed final order, which we don't have any problem with, that was filed with the exception of the amount of child support arrears or having an amount of child support arrears, says that the current child support is to start on May the 1st. So we have this gap between February 14th, 2022 and May the 1st, 2022, where the child was not receiving child support by Mr. Benjamin Hinojosa. So we would be asking today the court to approve a retroactive amount of $1,461.16, which is the amount of the current child support that the court ordered on May 17th, multiplied by the 2 months for within the gap of which are for March 2022 and April 2022.
Okay, so what was the amount again? 1461?
Yes, sir, Your Honor.
And Your Honor, as a response from Judge, we're not here to litigate the case. So this case was finalized, was proved up, Your Honor. He wanted to bring up any of those issues, Your Honor. Mr. Hernandez should have brought them up in the final hearing, Your Honor, and he failed to do that. So the MSA is very clear. He has it on the screen. And agree. We don't have an agreement. Discuss if any is due. We don't agree that any was due, Your Honor. And that's why specifically listed on the MSA that the parties are to agree. There is no agreement, so the court cannot modify, Your Honor, or change those terms. Second of all, we were here for a final hearing and he did not bring any of those issues up, Your Honor.
Your Honor,
Okay. Yes.
in my response, may I respond? MSAs are ironclad, as you know, through the family code, and they have in case law been more important than any final hearings that have happened and any final decrees. And final decrees have been changed by appellate courts off of the MSAs. If they go opposite of the MSAs, if they weren't agreed to. So because of that, we would ask that you do not entertain any of opposing counsel's mention of that.
Okay. So we did have a hearing on May the 17th.
Yes.
Your Honor.
All right. And we pretty much finalized everything, right?
Yes, Your Honor.
But we didn't discuss the retro, Your Honor.
We did discuss it, Your Honor. He didn't bring it up, Your Honor.
Okay.
Your Honor, we didn't discuss it. He said I didn't.
Well-
She said I didn't bring it up. I'm sure she didn't bring it up. We did
Okay,
not
but-
discuss it.
But did we discuss child support?
Yes, we did, Your Honor.
And we figured out, did we figure out a number in child support?
Yes, Your Honor.
Yes, we
What was
agreed
that?
to child support.
What was that number?
The child support, Your Honor, is $730.58, $175 for the medical to be provided by father's employer, and
Okay.
dollars on the dental insurance, Your Honor.
Okay,
Miss,
but at that point, the retro was not brought up, right?
No, Your Honor.
No,
It
Your
wasn't brought
Honor.
up?
We went over,
Nobody
we
brought
went
it up?
over
Okay.
everything.
No, we didn't discuss it as
Okay.
required by the MSA.
Okay. All right, anything else?
No, Your Honor, we just want for the court to consider, Judge, that we're not in agreement, and if the court is to entertain, Your Honor, that Mr. Hinojosa did provide support for Ms. Gonzalez and the minor children. He paid the rent, and she's kept property, Your Honor, that belongs to him as well, Your Honor, for the court to consider that.
Okay.
And my client is available to testify, as I'm sure everybody's
Okay.
available to testify as to those amounts, Your Honor, today.
All right, so then the decree has already been submitted for the court signature without the retro, right?
Yes, Your Honor.
I submitted my proposal, Your Honor, my proposed decree.
And I think right now, Mr. Hernandez just mentioned he had no problem with it, right?
Yes, Your Honor.
Except for he wants a retro. All right, at this time, the court will go ahead and will not order the retro in this matter. Okay,
Thank you, Your Honor. That's all we have. Can we be excused?
thank you all very much. You may be excused. Have a great day.
Thank
Thank
you.
you. What's next?
I got Mr. Gonzalez.
Okay. Mr. Martinez, we're still waiting on Mr. Gonzalez.
No, no.
Okay, Judge.
Plug it up.
I think he's logging in, but I hope it's.
Good morning,
All right.
Judge.
Yes, sir, Mr. Gonzalez. Good morning. I know you were in probate court, right?
That's correct, Judge.
All right. Thank you, sir. We're here on which case? Either F020. I'm sorry. F0225-22-4 in the matter of the marriage of Holly Day Cavazos and Luis Cavazos Jr., right?
That is correct, Judge. My client is
All right.
present and ready, Judge.
All right. There was a mediated settlement, right?
That is correct.
All right. You're just going to prove it up, right?
That is correct.
All right. And who's going to testify? Because the petitioner is Holly Cavazos.
Yes, she's
But I-
present. She's
She
present,
present?
ready. Yeah, in my office.
All right.
Judge, just for the record, Attorney Francisco Martinez for Mr. Luis Cavazos.
Okay. Good morning. All right. Let's put her on. Miss Cavazos, right? Holly?
Yes.
You swear that, good morning, ma'am. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. You may put your hand down, and Mr. Gonzalez, you may proceed.
Yes. Would you please state your name and your address for the record?
Holiday Cavazos, 3002 San Rodrigo Mission, Texas 78572.
Okay. Make sure you speak up loud enough so that the court reporter can take your testimony. You were married on or about November the 17th, 2001, and you separated and ceased to live as husband and wife on or about November the 15th, 2021. Is that correct?
Yes.
And the marriage has become insupportable. That means you don't get along, and there's no chance of reconciliation. Is that correct?
That's correct.
And during the marriage, 4 children were born, namely Is it Jamie or Jaime Nathan Cavazos? Delilah Marie Cavazos? Melanie Marie Cavazos and Susie Marie Cavazos, is that correct?
Yes,
Okay. And as the court indicated, we had a mediation where all the issues relating to child support, custody and possession have been worked out. In addition to that, there's no real property. You and your husband didn't buy any land during the marriage, is that correct?
that's correct.
There's also only personal property, and it's recited in the mediation settlement agreement, which you're requesting the court approve, is that correct?
Correct.
Okay. And just so that for the record, Judge, the child support is $18.31 a month that he will have to pay. Some of it is through Social Security benefits that children are receiving, and some of it's through his VA disability benefits that he receives. And in terms of the visitations, there'll be the now new standard extended visitations, Judge. And those have been agreed to. The only other issue was in terms of the pickup and delivery of the children, they will be at the theater in Mission, Tinseltown. It's located off the expressway. It'll reflect there in the order of where exactly to pick them up.
Okay.
He has agreed to pay rental payment that he was delinquent in, I believe it was in June of this year. He should pay it by the end of the month. In addition to that, he has agreed to pay on the vehicle that she will be keeping, which is a 2021 Pathfinder. He will be making 6 payments on that, beginning this month, and I believe it'll end in January of this year, next year.
Next year.
I don't think there's any other personal property. Each party will keep whatever's in their possession as their sole and separate property.
Okay.
There are no retirement plans. If somehow or another there are changes in the rules because he didn't do a 20-year hitch, she will get half of his VA retirement if he ever qualifies, or there's some changes. My understanding was that he doesn't qualify right now because he was only in the service for 17 years.
Okay.
That will be recited in the divorce decree. I'll pass the witness at this time.
I got no questions. I got no questions for petitioner, Judge.
Okay. Are you going to put on your client, Mr. Martinez?
Yes, sir.
All right. And that would be Luis Cavazos, right?
That is correct.
All right. Good morning, sir. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down, and Mr. Martinez, you may proceed.
Yeah, just to clarify on there's no confusion regarding the child support, Judge. His child support is $1,831.90, and from that amount, $736 will be deducted in disability benefits that the children currently receive. So his monthly actually will be $1,095.90 after subtracting the $736. I just wanted to clear that up. Mr. Cavazos, as you heard, Mr. Gonzalez, we did attend mediation. Is that correct?
Yes, sir.
And you recognize the document I'm holding in front of you?
Yes, sir.
That is the mediated agreement.
Yes, sir.
You understand that the terms in this agreement will be incorporated into a final decree of divorce.
Yes, sir.
And once you sign off, once everybody signs off on that, it will be submitted to the court. Are you asking the court to approve that decree?
Yes, sir.
Are you asking the court to grant you your divorce?
Yes, sir.
Are you satisfied? Are you satisfied with my services?
Yes, sir.
No further question, Judge.
All right. Thank you, sir. Mr. Gonzalez, what about a name change for your client?
She didn't request a name change, right?
Okay. Okay, I just thought I'd mention it. Okay, very well. Court will take judicial notice of the entire file in cause number F0225-22-4 in the matter of the marriage of Holiday Cavazos and Luis Jaime Cavazos Jr. Court will hereby approve the agreement of the parties. Court will go ahead and dissolve the marriage of petitioner and respondent. Court will await a decree for signature. All right, thank you all very much. Good luck, and you all may be excused and have a great day.
One last
Thank
thing,
you,
Judge. Will the court require that the parties sign off on the decree? It will?
Yes, as well.
All right.
Mhm.
I believe Mr. Martinez is working on it.
Yes,
All right.
it's ready. I'll forward it to you as soon as you review it.
Okay, very well. Thank you all so much. You'll have a great day.
That's all we have.
Likewise, be safe.
Yeah, bye-bye.
Number 5.
Number 5. Okay, the court will continue here with the August 10th, 2022 docket, and I have F2571-22-4 in the interest of a child here. And Mr. Salinas and Ms. Williamson, good morning.
Good morning, sir.
I believe last time we ordered DNA and we've already got it, right?
That's correct, Your Honor.
Okay.
That
What do
is
we see?
correct, Your Honor. The
Here-
DNA, if I may, Your Honor, the DNA came very conclusive, and we are not questioning parentage at this time, and we'll concede to parentage.
Okay,
So
Your Honor,
that one,
since they conceded, I mean, the DNA is clear on that. We're asking that the birth certificate be amended to reflect Jose Antonio Garcia Jr. as the father, and that the child's last name be changed to Garcia.
we are going to object, Your Honor. I think that's a matter for the Department of Health, and when they are not married, the father's name will not appear as the child's name will not be changed. We have no objection to the birth certificate showing him as the father. We would object to the last surname being changed. I think it's a matter for the Department of Health.
No, sir, that's a matter that on any paternity, Your Honor, the court rules on that issue. It is not, the health or vital statistics cannot change anything without a court order. It's in the best interest of this child that all children have their father's last name. That's what this court normally does. That's in their best interest. So we are asking, my client didn't even have an opportunity to name this child. It's his first child, that at least the last name changed to Garcia.
Your Honor, the issue is not before the court. They have not requested a name change.
Yes, it is, Your Honor.
is it in the petition for the name change?
Yes,
as
Your
well?
Honor. If he is found to be the father, yes, that the child's birth certificate be amended.
You got that in the petition? In the petition?
That's not a
Yes,
matter
Your Honor.
set for today, Your Honor. That's not a matter set for today.
Okay.
Yes, it is, Your Honor. It's establishing, we can't amend a birth certificate saying he's dad and then amend it again to say his last name. I mean, he is the father.
Okay, he's the father. All right, it'll be amended. It'll be changed.
Thank you, Your Honor.
Okay.
And Your Honor, at this time, we are asking for visitation.
Okay, we have a
Even if
child
it's-
under 3 years old, right?
We have a
That is
child
correct,
that is
Your Honor.
2 months old, Your Honor.
Okay,
Correct. Your
And
Honor,
he's transitioning from breastfeeding to bottle feeding as we speak.
okay. Is the baby healthy, by the way?
Yes, the baby is healthy.
Healthy, doing fine and everything?
Yes, sir.
Great. Okay, good to hear. So
Your
now
Honor,
we
this
need.
is my client's first child ever. He's not even met this child, has not even seen this child. His parents are first-time grandparents of this child, have not met their first grandchild. It brings me to tears that this child's already 2 months, the most formative time for children to form a bond with grandparents, parents, and my client hasn't had to do it.
There had been no adjudication of parentage, Your Honor. I don't know why they would bring Ms. Williamson to tears. There had been no adjudication of parentage. It's very seasoned in family law, and until there's an adjudication of parentage, the issue of visitation is improper. So I don't know why they would bring her to tears. And
Your Honor, it brings me to tears as a human being, Your Honor. We all knew it was his child. I'm talking about as a moral issue, as a human being. She well knew that it was his child.
Okay, so we're gonna have some visitation. It'll be no overnight, right?
Correct. We're not asking for overnight, Your Honor. We're just
Okay.
asking for Saturdays and Sundays.
Saturday through Sunday. But
Saturday, no overnight, Mr. Salinas. We're just asking for Saturday and Sunday during the day.
Your Honor, the family code specifically says that on a newborn, visitation is limited. We have no problem with visitation. We know that he is entitled to visitations. However, the child is a mere 2 months old. The the father works at a detention center where there is little, if any, control about the pandemic. So visits need to be short at this point. They need to be supervised. And we have no problem with visitation. We had recommended, we had stated, we submit that 2 hours per day supervised at the home of Ms. Chantel's parents. And from there on, the family code specifically says the court can enter a graduated visitation schedule.
That's what I'm looking at, something that was gonna be graduating.
So I
We
would
gotta start
recommend
somewhere.
2 hours
Right,
a day to
you're-
start. The child does not know this man, the child. We're just starting. We need to start on a gradual. It's what's in the best interest of the child, Your Honor, not what's in the best interest of the father or the grandparents or the great grandparents or the uncles. What's in the best interest of the child? And right
I
now,
agree.
this child knows only the mother. That's the only contact he's had. Any contact with the father has to be gradual.
Okay,
Your Honor, I agree with Mr. Salinas that it's not in the best interest, whatever. We don't need to consider the best interest of the father. We don't need to consider the best interest of the mother. The father has not had any contact with this child because of the actions of this mother, not because of the actions of my client. We had to bring this action because she didn't even notify him that the child had been born. There is no evidence of any family violence. She's a new-time mother. Granted, my client's a new-time father. He needs to have time to bond. 2 hours supervised. I'm sorry, Your Honor, that's not to bond. The code is real clear under section 153 that the court may consider a child, but it's not must. Yes, you can deviate, but that is at your discretion. And there are reasons to deviate. Is there family violence? Is there history of drug use? They're both first-time parents. He needs to bond with his child. What I'm saying, he hasn't met his child. If he could see his child today, I'd be more than glad to. If I can finish, Mr. Salinas, I tried not to interrupt you. I'd be more than glad to supervise here. I have 1, 2, 3 adults that can also supervise along with my client that supervise visitations, maybe from 12 to 4, just today. And then we can go on whatever his days are. We're not at this time until our final hearing. We're not asking for overnight, Your Honor.
well, his employment, what are the hours? What are the days?
Your Honor, he is off.
I'm off Monday through Thursday. I work 4 days on, Your Honor, and 4 days off. So today's my last day off, Your Honor, and then I will be working Thursday, Friday, Saturday, Sunday, and then I'm off Monday, Tuesday, Wednesday, Thursday.
Okay, so then you wanted to have the child on Saturday and Sundays, but you're gonna work on those days?
Yeah, for right now, Your Honor, we're asking, since it's just going to be during the day, that we're asking if he could have, like today, because he's off, and then next week, Monday, Tuesday, and Wednesday, during the whatever the court hours the court wants to have.
So his days off are Monday, Tuesdays, and Wednesdays, and what else?
They rotate a day every week.
So it moves
Okay.
on.
Wow. Okay. I'm a little bit confused with the days, but anyway. So on the days off is when he likes to have the child, right?
That is correct, Your Honor.
Okay.
Can I address the court, Your Honor? Once she's through, I'd like to address the court on that because.
Okay, let me just see what she's proposing. On the days that he's off, you want a couple of hours, 3 hours?
Yeah,
Or so.
12, maybe 12 to 5 to have the child.
But at the grandparents' house, right? To be
No,
supervised
Your
at the
Honor, it could be at his parents' house.
That's what I'm saying. His grandparents.
Yes,
Yeah. His parents' house.
correct.
Okay.
At his parents' house, Your Honor, we're going to object. We ask that the supervised visits be at her parents' house. He has visited the house before. He's been a welcome visitor there.
They get along?
They get
No,
along.
sir,
He's welcome to go to her parents' house.
I think the lawyers do not get along. I think the parents do and the grandparents, not the lawyers. So we figured that out already.
We're prepared to put up testimony.
Okay. No,
Supervised
I
visits
don't
should
want to.
be at her parents' house to start.
What
Let the child be
we can do is this. Look, we can do the first visit at her parents' house, next
Okay.
day his parents, and then you can alternate, okay?
Mhm.
Alternate.
But I would recommend no more than 2 hours, Your Honor. This baby is a day old, he's 2 months old.
I say 3 hours. 3 hours, that's about right. Okay? I think we can work it out, guys. I mean, if everybody's fighting like if this is a one of those bills in Congress,
Okay,
we're
Your Honor,
putting too
can
much
he,
to, yeah.
can
Is
he
that
meet
3
his
hours a
child
day, Your
today?
Honor, a week, or 3 hours a week, or?
It'll be the 3 hours a day. By the time you go in there and you,
For,
All right, let me
for how
see.
many days, Your Honor?
well, I was gonna suggest one and one day with this grandparent, and then the next day the other grandparent, and then go like that. And then after a couple of months or so, or maybe after the first month, we can graduate to something else.
Mhm.
At least a couple of months, Your Honor. The child needs to be given an opportunity to familiarize himself with the environment. We're
Okay.
thinking of the parents, and we're forgetting about the child who's 2 months old.
Okay. Okay. You know what? I think I got a better idea. Let's go to the 2 hours, like for the first week, second week, 2 hours, and then the third week and fourth, 4 hours. I mean, 3 hours, and then see, we're graduating here, and then
Okay.
after the first month, well, let's see.
Well,
I'm
sir,
just
we
trying
can
to-
set it for a final after a month.
Well, you know what? For the first month, let's try like I said, and then we'll
Okay.
come back for a final, and we're gonna try to more or less stay with the same.
2 hours a
idea.
week, Your Honor? Is that 2 hours a week?
A day. Give it
For how many days?
for 3 days.
I would recommend 2 days, Your Honor. I think 3 days is too much for.
Well, what's gonna happen
2-month-old
is,
baby.
I don't know the days that he's off or he's working. Is it 4 days that he's off at a time or what?
She also works, Your Honor. She also works.
Okay, so the baby's away for her for 8 hours a day. If she also works, Your Honor, why can't he take care of the baby
Because he's
for
at
those
the
8 hours?
environment where he was born. That's
Yeah.
why he's used to that environment.
No, look, the first week, let's try the first 2 weeks, 2 hours, and then the third and fourth week, 3 hours. Okay?
A day for 3
A
days.
day.
that he's
It'll
off.
be every other day, one day him.
Oh,
one
every day, other day,
Yeah.
okay. Your Honor,
But,
can he,
but I'm talking about the days that he's not working.
correct, Your Honor.
Okay? The days that he's off, those 4 days or 3, I don't know how many they are.
Yeah.
On those days, you alternate.
Okay. And Your Honor,
Okay.
can he meet his child today? I mean, I will be more than glad to supervise. I'll get his father here.
All
He
right.
wants to meet his child.
All right, we can do that 2 hours today,
Okay.
Your
2
Honor,
hours today.
let me emphasize one thing. The
What?
baby is not vaccinated. The doctors have recommended that the child stay in an environment where all the surroundings are vaccinated. We don't know what the status is at that house.
Okay, they're gonna wear the
Yeah.
mask. Everybody's gonna wear a mask.
Yeah, no, and Your Honor, if the visitation is here in my office, I have a 90-year-old mother, so I'm like COVID crazy. Everybody has to be vaccinated at my office. Everybody has had to have all their boosters or they cannot be here. We test, again, I protect my 90-year-old mother. We test, I make them test. They're not, I mean, and this is gonna sound horrible, but they're not even allowed to go out to lunch during the week. They must eat here. We fix food here. And so our clients are required to wear masks.
Yeah, wear a mask.
Yeah, because again, it's just, I need to protect a 90-year-old. And there's several other people here that either have disabled husbands or elderly parents like I do. So I'm very protective about that. Everybody's
Okay.
vaccinated up to 4. That's why I suggested this place. We disinfect on a regular basis.
That'll be convenient also, Your Honor, because the father's mother works right there at the office. She's Ms. Williams, is paralegal, so
Correct.
I can
Oh.
see why she favors that.
I don't favor it for that, Your Honor. They wanted their home, but I'm just trying to make it where they don't complain about COVID, where they don't complain about the distance. They
Well,
will
those are
have,
legitimate complaints, Your Honor. We're not complaining, we're urging safeguards.
Okay,
yep.
okay, make sure you have all those safeguards, Ms. Williamson.
Okay, yes, Your Honor. And what time can she be here today?
What's today? Today's, it'll be 11 o'clock, at what, 1 o'clock?
Yes, 1 to 3?
1 to 3?
Okay,
Okay.
Is that okay?
That's
Yes.
fine.
Oh, okay.
That'll be at Ms. Williamson's office?
yes,
Right,
Your Honor.
right.
At 210 West Seminole in Edinburgh.
Very
And we
well.
will disinfect at 1 o'clock or at
Please
12:30.
do. Wear
All right.
masks.
For our
Yes,
masks, for
sir.
everything. Okay. All right. So let's try the first month here, and then we'll come back for the final hearing. Unless you
Thank
guys
you.
can agree on it and sign on something, everybody, and that'll do it. You know, we don't have to have a hearing.
Could he put on the record just so that we can have it, Your Honor, what his take-home pay is?
I will provide all his pay stubs, everything, Your Honor, and we'll start child support from date of birth. No problem.
Okay.
Oh,
So that's not even an issue.
I was just curious. I wasn't saying it's an issue. I was just asking.
Yeah. Okay. You're just trying to cover. Okay. Now, no problem. Just submit that. Okay, man.
Ms. Williamson,
Yes, sir. I'll
don't be
prepare an
so-
order.
Ms. Williamson, I'm an old man. Don't be so combative with me.
I'm an old lady, Mr. Salinas.
No, Mr. Leonard, there were slow blows today. Okay. They were real slow. Okay.
You know, I can't be mean to you all that much, Mr. Salinas. You're one of the nice guys.
Well, thank
One of
you.
the
I
few.
heard that.
One
Your
of the
Honor,
few remaining.
Your Honor, could I have a copy of that record?
Well, that's the court coordinator. Okay. She'll give it to you.
Yeah.
Okay.
No, you've always been a gentleman to me, Mr.
Yes,
Salinas. I can't complain.
Yeah.
You
One of the
always
few
have.
remaining ones. Yeah. One of the
Yes,
few remaining
sir.
gentlemen that are out there. I agree.
Yes,
I agree.
sir.
Thank you.
All right.
Thank you, Ms.
All right, I'll prepare an order, sir. Thank you.
Thank you all very much. You want to be excused.
Bye-bye.
Have a great day. Stay
Thank you, Your
safe.
Honor.
Stay safe, by the way.
Yes, sir.